Today I'm going to talk a little bit about what happens when you retain our law firm to do either a Chapter 7 bankruptcy or a Chapter 13 bankruptcy. Generally, to do a Chapter 7 bankruptcy, we cannot file the case till our fees and the credit counseling fees are paid in full. However, for $50, it is well worth it for us and you especially to open up a file. For $50, what we do is we put you in our computer. We give you a card so you can refer all creditors to our office. That way you don't have to deal with creditors. You simply say, I will not pay. I am filing a Chapter 7 on a given date. My lawyers will be Mayor Newton, and please call their office for case number information. And we provide an 800 number. Generally, we of course tell you to continue to pay for secured items such as your house and car if you're going to keep them, or for maybe your student loans or recent taxes. We also send you, if appropriate, do not contact letters. These are letters that will be addressed to by you in self-addressed stamped envelopes that we provide to your creditors. The letters, which will be drafted by our office, will generally say that we represent you, do not contact you, you will not pay the debt owed to whatever firm or creditor we are writing to, and that most importantly you are a represented party, and for the creditor to contact our office by email only. Being a represented party has some legal consequences that will greatly benefit you. If you are represented, a third-party debt collector or a debt buyer is not allowed to contact you. That would be a violation of the Fair Debt Collection Practices Act. If they do contact you after receiving notice of our representation and you take notes on such contact, there's a possibility that they will have violated the Fair Debt Collection Practices Act, of which you'll be entitled to $1,000 statutory damages. That's why we put in our letters that you are a represented party. We are representing you. We are advising you not to pay your bills in light of the fact that you will be filing bankruptcy in a short period thereafter our representation has taken place. In Chapter 13, generally it's no money down other than the $50 for credit counseling. Generally in Chapter 13 cases, your case is filed almost immediately, so there's, other than the card that we provide, there's no reason for us to send the letters, because once you file your case, it is illegal for your creditors to communicate with you in order to collect the debt. In bankruptcy, if a creditor does attempt to collect the debt and that they are aware that you are in bankruptcy, they will have violated the automatic stay. The automatic stay is the most powerful injunction in the federal code. It means creditors cannot collect, and they are subject to the bankruptcy shield of protection unless they ask the court to remove it. For example, your car creditor or your mortgage creditor can ask the court to remove it in order to proceed to foreclosure or repossession if appropriate. However, if the creditor willfully violates the automatic stay, they can be sanctioned for violating that. You will be entitled to your actual damages, such as having to come to our office, missing work, possibly emotional damages, plus the attorney fees for us having to prosecute that action. Your creditor will be the one ordered to pay those fees. If for some reason we undertake a lawsuit for violation of the automatic stay and we are not successful, you do not pay us any money. We are looking for the creditor to pay our fees. So once you retain us, you'll be in a position of not having to worry about paying many of your bills, other than the ones that we will discuss at your free consultation in our office. Thank you.